Chrysler.
And where is that located relevant or relative to the crime scene?
That is to the west of the crime scene, so it's on the west side of 75.
Okay. And in this screenshot, can you see where 375 is in relation to the subject?
Yes, sir.
And where is that?
It is. It's at the top of the screen. There's a guard rail. It's on the other side of that.
Okay, and so coming from the crime scene, would you have to cross over the freeway to get to this point?
Yes.
Okay. And what's the time again of this?
Oh, I don't recall. Can we go back to the screen prior? Okay, this is 4:24 a.m.
And do you see the what appear to be the shoulder straps on the individual at this point?
Yes.
Before this point in time, were those, I guess, visible in any other videos that you observed of this individual?
Not prior, no.
Okay. And what's the next point reflected here and the time?
Yeah, so this is 421 Madison, which is 36th District Court. It's October 21st, 2023, and it's 4:29 a.m.
Okay, so would it be fair to say this is moving west from the last point?
Yes.
Okay. And I guess what's the significance of this screenshot that follows that point?
This is the person that I was tracking.
Okay, and that would be at the 36th District Court location?
Correct,
Okay.
yes.
And then what's the next point and time reflected here?
There would be Cass and Charlotte, which are streets. It's an intersection. It's 4:45 a.m.
And if we, when we look at the overall compilation video, are we going to see video between points 9 and 10?
Yes.
Okay. And what's the significance, I guess, of the screenshot that follows at that point in time?
This is beyond the 36th District Court?
Yes.
Okay.
Yeah.
This is the individual I was tracking, walking north on Cass.
Okay. And what's point number 11? What's the location and the time associated with that?
This is 454 West Alexandrine. That is an apartment building, and it is 4:55 a.m.
And is that the same as the point of origin?
Yes. That's what it
And
said.
again, when we look at the overall compilation video, are we going to see more video footage from between points 10 and 11?
Yes.
And the screenshot immediately following point 11, what's the significance of that?
That is a person coming into the building.
Okay. I want to publish Exhibit 78. And, Your Honor, just for the record, this is going to be a bit lengthy. I don't, if the court, just throwing that out there, if the court wanted to do a break now or at some
You
point.
need a break? How, I mean, more than half an hour, or?
It's an hour and a half, and there's going to be a couple of questions in between.
Well, we won't even.
And, no, I understand we're not going to get it done today.
Do we need a quick break?
No, sure. Just
Okay, 5 minutes just for the restroom? Okay. We'll break for 5 minutes.
Alright.
was actually rescheduled for June 24th. Ferreter is charged with aggravated child abuse, false imprisonment, and neglect of a child, and that dates back to December of 2021. Prosecutors say Tracy and her husband, Tim Ferreter, locked their adopted son in an 8x8 box in their garage for hours in the dark as a form of discipline. He had to go in the bathroom in there. I mean, you remember the case. It was terrible. Tim Ferreter was found guilty in October of last year of the same charges Tracy is now facing and was later sentenced to 5 years in state prison and then 5 years of probation after that. Now, during Tim's trial last year, audio of Tracy reprimanding their adopted son was played for the court to show the jury the various forms of verbal abuse that the child experienced as well. Take a listen to that.
Do you have pajamas? Are those them right there? Do you hear me? Oh, here we go. Back to this where you can't talk. You're a middle school boy. You want to do all these things. You want to do chess. You want to do things. But you can't talk because you got caught being dishonest. Okay. Well, that's fine. Guess I'll just keep giving you more chances. Every day, new chance for even though doesn't care, he doesn't want to be nice to anyone. Oh, let's let do this. Oh, let's let me bring some food because I think he's gonna have a good night. Oh, let me do everything for okay. Oh, can't talk because he got in trouble because he got caught. It's like, give me a break. Start owning up to what you're doing, and then try to fix the problem, like we keep telling you.
Now, Ferreter has a tentative trial date of July 12th. For a look back at the case against her, here's Court TV's own Julia Janae.
Even before the verdict was announced in the case against Timothy Ferreter, the stress and fear of what was about to come was apparent. His wife could not hold back tears.
We, the jury, find as follows. As to count one, we find the defendant guilty of aggravated child abuse as charged in the information.
Jurors would go on to find Timothy Ferreter guilty of false imprisonment and neglect of a child.
Juror 1, were the verdicts as read your verdict? Juror 2, were the verdicts as read your verdicts?
Yes.
The 6-person jury found Ferreter guilty of charges related to the treatment of his adopted son. Tim and Tracy routinely kept their son confined to a windowless room in their garage with a bucket for a toilet. Jurors heard from the minor child, RF, now 16 years old, about what it was like to live in that room.
Did you like being in that room?
No.
Did you want to be in the room?
No.
How did it make you feel?
To me, being locked in a room, it's dehumanizing. It's almost as bad as genocide. It's saddening.
The judge asked us not to show RF or his sister, FF. Both, still juveniles, were witnesses for the prosecution. The defense lawyers conceded that Ferreter made some bad parenting choices in trying to address his son's severe behavioral issues, but they argued he acted out of concern for his safety. The jury requested a chance to review FF's testimony before returning with their guilty verdicts. She testified about seeing her brother being abused.
I was worried that one day that he might accidentally, that he would accidentally kill.
And is that based on the physical force that you saw?
Yes.
And the level of anger and aggression you saw the defendant use towards your brother?
Yeah.
At this time, I'm going to remand the defendant to the custody of the Palm Beach County Sheriff's Department.
Tim Ferreter turned down a plea offer from prosecutors in the weeks before his trial.
Have you made a decision whether to accept or reject the offer?
Yeah.
All right, and what is that decision, sir?
To reject.
Defense attorney Priya Murad said the plea deal was not so clear-cut.
The plea deal that we were provided was 2 years followed by 5 years probation, contingent on Tracy either taking a plea or Tim doing a proffer against Tracy. I had asked the prosecution what the plea for Tracy would be, and we never knew it.
Tim's wife, Tracy, faces similar charges. It's not clear if a plea offer is going to be made in her case, and a trial date is expected to be set after Tim is formally sentenced.
All right, he wouldn't testify against her. Joining us to discuss, criminal defense attorney, former prosecutor David Bruno, and criminal defense and civil attorney Jesse Lal here in studio. David, I want to start with you. What we found out today, it was a conference for the plea, but it was pushed from the 10th, which is today, to the 24th. As a former prosecutor, what does that tell you about what might be going on?
The defense needs time to get ready. We also know that in the prior appearances, the attorney said he couldn't be ready by January. But now, since things have moved, and the judge did make a comment when he pushed it back, saying that due process rights was a concern. So anytime defense is looking for time and they're giving good reason, investigation, preparation, new discovery, whatever it is, I think courts are right to push it back with the concern of violating due process rights, because this is a trial where she will be going to jail if she's convicted.
But let me ask you this quickly, quick follow-up. It was a plea conference on the 10th, moved to the 24th. We know the trial date is in July. Any prospects that they're trying to work out or come to a deal? Would that be what's going on?
That actually says to me that is one of the reasons it was pushed, to give the defendant time. Look, she should really consider it without a doubt. This is a rare occasion where you really do get a preview of the state's evidence, because her husband was criminally charged, prosecuted, and convicted. And the evidence we can expect to be very, very narrowly tailored to also meet sort of her actions and responsibility as well. So I think it would be good for her to consider. I don't know what the numbers are, but with that being said, she already knows her husband's been sentenced to 5.
Jesse, we know that an offer was made to him, 2 years with 5 years probation after release, but there were some contingencies. He had to testify or proffer against her. Obviously didn't want to take that deal, ended up with 5 years and 5 years probation. It would make sense, and it always made sense to me, that she's clearly, to me, she claims she's not guilty. I think being in the home, we have some video, I'm sure there's more video of her reprimanding the children, doing whatever, that she was along for the ride on this. She sort of signed off on it. Unless she could come in and say that maybe she was under his thumb as well, is there any chance that she would go to trial and be found not guilty?
There is a chance if she claims that she herself was being emotionally or mentally abused by her spouse, and that he was the one calling all the shots and dictating the terms of whatever form of corporal punishment was appropriate in his twisted mind. You know, it's in terms of what David mentioned also in terms of due process. This is also an opportunity where the judge is saying, you have to consider this plea because you've already gone through this trial. Your children have already testified against the father. The defense should get a transcript of that trial and go pour it over with their client and saying, this is what could be possibly brought against you. Maybe they're having her seriously consider a plea offer if one is made to her as well. So it's not so much also what she can anticipate at trial, but also what she's up ahead, because she's already had a preview of what it took to convict her husband, and it may not take that much to convict her as well.
Yeah, she's got to see that from that trial. But here, we learned from motion practice, David, that she plans to call another expert. This expert is going to testify about the challenges faced by adoptive parents when they have children with what RF was afflicted with, and that's reactive attachment disorder. By all accounts, very difficult to deal with. They tried something similar during Tim's case. I thought it fell flat. Is this something that might work, this approach to say, look, this was necessary because this was such a difficult situation?
Sure. I mean, he already tried that once, and I think one of his major problems was he did not testify, especially to explain some of the egregious allegations. Our audience is looking right now at the 8x8 room that was put in the garage of this family, and this 11-year-old at the time was made to go in there long hours, eat there, go to the bathroom there. I mean, so when I'm reviewing this in preparation for today, I could see that there were problems with the child, but that is not the answer. And I think that's where the defense falls flat. That's one particular angle that she could take, that it was necessary. And the other is to try to disconnect herself with the husband and point the finger at her husband. And we do know that there's ring video, thousands of ring video, and we didn't see them all at the first trial, but I could only imagine what type of other videos they have that will be applicable to this particular victim, this defendant. I think it's egregious. The 8x8 box, that's not the way to handle a child that's not listening or has psychological issues.
Yeah, those facts are going to be very difficult to overcome. And I can tell you who knows what's on those tapes. Tracy Ferriter.
to proceed?
Yes, Your Honor. Yes, Your Honor.
Okay. A couple of things just for folks in the audience. I know there's people here, presumably on both sides. This is an emotional time for everybody. If you feel like you cannot contain your emotions within the courtroom, I'd ask that you please wait in the hallway till after the jury has completed their work and they're discharged, and then you can express whatever emotions you need outside the courtroom. I just don't want there to be any outbursts or anything that would impact the jurors in any way, whether it's satisfaction or dissatisfaction with their decision. So you're ordered not to remain in the courtroom if you don't think you can contain your emotions. With that, we're ready to bring in the jury. While we're waiting, and again, the state and defense defendant are present, is either side going to want the jury polled?
I believe that's reflected in the...
If it is, I have the polling question. That's the standard question as part of death penalty cases promulgated by the Supreme Court. So I can use that.
Yes, yes, please.
Okay.
Entering.
All right, please be seated. Ladies and gentlemen of the jury, I've been informed that you have reached a verdict or a decision in this matter. Is that correct? Who has the verdict form? All right. You'll pass that to the bailiff. All right, verdict form appears to be in order. We'll let the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Forley County, Florida, criminal action, State of Florida versus Wade Wilson, case number 19 CF 568. jury verdict form, penalty phase. We, the jury, finds as follows as to the defendant, Wade Wilson, in this case. As to count 1, first-degree murder, Christine Milton. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes. We, the jury, find unanimously that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. No. If you, the jury, answered no to every aggravating factor, you have completed your deliberations. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, unanimously found the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 9-3 that Wade Wilson should be sentenced to death. As to count 4, first-degree murder, Diane Ruiz. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of aggravating factors. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, unanimously found the state proved 1 or more aggravating factors. Each of us has considered whether 1 or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. We, the jury, find by a vote of 10-2 that Wade Wilson should be sentenced to death. Dated this 25th day of June, 2024, in Lee County, Florida, 4-person 234.
Does anybody want the jurors to be polled?
Yes, please.
Okay. Members of the jury, we're going to ask each of you about the jury's decisions that you have just heard. And I'm going to go juror by number. So juror, do you, juror 97, agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror 97. Okay. Do you agree that the decisions read by the clerk accurately reflect what the jury decided?
Yes.
Juror 234. Do you agree that decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Juror number 3. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror 205. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 101. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 215. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, Your Honor.
Juror 87. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 362. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, sir.
Juror 136. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Juror 193. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes, sir.
Juror 315. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided?
Yes.
Juror 309. Do you agree that the decisions as read by the clerk accurately reflect what the jury decided? Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We've recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, we thank you again for your service. Gather your belongings, make sure you don't leave anything in the jury room, and the bailiff will escort you out. You are discharged.
All right.
All right. Please be seated. All right. What says the state in regards to sentencing? I know we have to have a Spencer hearing.
Yes,
And-
we do need to go ahead and set it up for a Spencer hearing. We also need to have a pre-sentence investigation.
Okay.
On the,
All right.
so we're thinking 45 days out.
Are the parties available on July 22nd?
July 22nd?
Yes, sir.
No, sir.
Okay.
I'll be
How
flying
about-
back from
oh,
Wisconsin.
Okay. How about July 29th?
I'm supposed to start a second-degree murder trial in Arcadia on the 29th. I can't be ready that fast.
How about on July 23rd?
That'll work.
That works for the state.
What time, Judge?
9 a.m. So I'll order a pre-sentence investigation report and have the Department of Corrections prepare that. And then we'll set sentencing and Spencer hearing.
I want the Spencer hearing at 9 and the sentencing at 1.
That's fine. We can do that, start in the morning and then recess until the afternoon. So I'll give you all day on Tuesday, July 23rd, beginning at 9 a.m. Mr. Wilson, I believe he's already been fingerprinted, but it may need to get fingerprinted again and remanded, or does he need to get fingerprinted? Okay. Then he'll just be remanded. You'll be held without bond until July 23rd, what's a sentencing and Spencer hearing on July 23rd, beginning at 9 a.m. Any other issues that the court needs to address?
Thank you. Yes, sir.
All right, thank you. Then we'll be adjourned.
Who is in Houston? Do you have family there?
Yes, my whole family stays out there. That's my farm.
All right. So what were you doing here in San Antonio?
Jeez. I was young and dumb.
Well, how old are you?
Things.
I'm sorry, court reporter can't hear you. You're gonna have to open up.
I was young and dumb, just getting into the wrong things I shouldn't have been.
How old are you?
I'm 21 now.
All right, and how old were you when this offense was committed?
I was just turned 19.
19, so you leave the safety of your family to come down here with Christian Dunbar. How do you know him?
School.
School where?
Eisenhower.
What?
Eisenhower High School.
Okay. Are you employed?
No, at this moment, I'm not employed. I was employed, but I ended up losing my job. This case.
Well, people always say I ended up losing a job because of a case. Really, you end up losing a job because of your actions. So that it's better to say it that way because then you're owning your role in the loss of your job. You understand?
Yeah.
So how far did you go in school?
I graduated high school.
What are you planning on doing with the rest of your life?
And I'm working on right now. I'm working on getting employed, so I go get me a trade,
Mhm.
so I can get my life together.
Do you have any children? Okay, yay, that's a good thing. Don't have any children until you have yourself in order. You understand?
Yes, ma'am.
All right. This is what the court is going to do. Court is going to sentence you to a $500 fine. That will be probated. 2 years deferred adjudication. There's to be restitution, if any, and no contact with hometown pest defense. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. If you're drug tested today, what are the results going to be?
Negative.
Why do you say negative?
I didn't really know what to say at the moment for that.
All right, have you used drugs in the past?
I only smoke marijuana.
All right, so are you going to be positive for marijuana today? I'm sorry?
Yes, ma'am.
All right, that's a drug. All right. So how often are you using marijuana?
Okay.
All right. So I want him tested for levels. So when you haven't been employed, you just been sitting around the house smoking marijuana?
Not really. I've been working with my uncle. Like,
All right. Well, you're saying you're using marijuana every day.
you answered your question. I just.
No, I mean, so you've been using marijuana every day?
Yes, ma'am.
So when do you find time to work with your uncle?
During the daytime.
All right, so you just using marijuana at night?
It depends on my off days. I smoke in the morning and at night. But if I,
All right, and where are you smoking? Hopefully, are you living with your parents?
yeah, I stay with my mom.
All right, I hope you're not smoking in your mom's home. All right, I'll take that as a yes. You can't be smoking marijuana at your mom's house. Does your mom allow that? I mean, she has to know. I'm sure it smells.
But she got on me a couple times to not smoke in the house. I started smoking in the house.
All right, well, you shouldn't be smoking at all. So I want him tested for levels. He needs to do a year of sober meetings. You're going to do a year of sober meetings for 1 year. So you're doing a sober meeting a day. Because if you've been smoking marijuana every day and eating cornflakes or whatever you're doing, that's not a good thing. You've got to get your life together. You're young. This is a crime of moral turpitude, but you're young. You still can change your ways. But if all you're doing is, when you're not doing part-time work with your uncle or somebody, if the only other thing is you're sitting back at home eating and just smoking marijuana, that's not a good thing. Your brain is idle. You understand?
Yes, ma'am.
So, yes, he's doing a year of sober meetings. So you need to do a sober meeting a day, and you need to start getting your life together. Stop using marijuana. This is Texas. Marijuana is not legal in Texas unless you have a medical prescription for it. And while you're on probation, you're not allowed to drink alcohol at all. Your attorney will tell you that those are not my rules. That's the law. You can't drink alcohol at your house. So if somebody wants to come over or have a picnic or whatever is going on, or having a barbecue and they have alcohol, you're not allowed to partake. Do you understand?
Yes, ma'am. Okay.
If you do, you're looking at 1 year in the Bexar County Jail. All right?
Yes, ma'am.
And as a judge, I could order, if I would have seen you to Bexar County Jail, that whole 2 for 1, 3 for 1, I could tell them I don't want you to have 2 for 1 or 3 for 1. So you could do an entire year behind bars. Now, some inmates over there, they make alcohol. I would tell how the recipe goes. This is not from my personal experience, but this is what clients have probably told me and Miss Bill on how you make marijuana and cosmetics at the jail, but we're not going to do that. So you're going to do 1 year sober meetings. I'm going to do 80 hours of community. No, I'm going to do 120 hours of community service restitution. And if you obtain your GED, not your GED, if you obtain a certificate, you can still be a welder, you can be a plumber, you can do all of those things. If you obtain your certificate in either of those fields or from some other type of trade school, I will waive your community service hours. So it's to help you improve yourself. All right, they're asking for CATS 1 and 2. CATS 1 and 2 is a theft course. I'm gonna give you my theft course. And the reason why I'm gonna give you my theft course is because I've ordered you to do a sober meeting a day for a year. So here's my theft course. Don't steal. Don't take what doesn't belong to you. Those catalytic converters, guess what? They're expensive. You shouldn't have taken them. Don't hang around with other people who steal. People don't like people who steal. You understand? So that's my theft course for you. And I'm gonna give you my criminal trespass course while we're here, because I know your age and I know what ends up happening. If you are ever invited to someone's home or invited to a party or somewhere else and they ask you to leave, you need to leave. If one of your friends comes up to you and says, I'm going to this party, you want to come with me? You know what your next question to them should be? Are you allowed to have a +1? If they're not allowed to have a +1, that means you're not invited. And then here's just another side note. Nothing good happens at midnight. Even if you're at work, guess what? Nothing good is happening at midnight because, hey, you're at work. If you're at your house and you're wide awake at midnight, guess what? It's because you have insomnia. Nothing good happens after midnight, especially if you're out and about. You understand?
Yes, ma'am.
We can go off the record. Do you know what Denzel Washington said? I think he told another actor, he always leaves a party 30 minutes before the devil arrives. So you need to leave 30 minutes before they arrive. Or I like to say before the craziness starts. All right, we're back on the record. Probation, is there anything else he needs? Well, he's gonna be, transfer to Harris County. He's gonna be in Harris County. I don't know if you're all able to do field visits there. Are you all able to do field visits there?
I'm not sure what the probation department there allows, but I can note it.
All right, I'll order field visits one time per month for 3 months. All right, is there anything else you need from me to be successful? Okay, oh, and I'm sorry, proof of employment within 45 days. No employment as a home health care provider or with minors. We can do a TAP evaluation out of custody, and we'll see what the recommendation is. If the recommendation is for inpatient treatment, we'll start him with outpatient treatment. Okay. And Ms. Bill, if there's an issue with the restitution amount, we can come back and have a restitution hearing.
Okay, thank you.
And usually what ends up happening, if I see a large restitution amount, I'll have Norma contact you all.
That'll be great. Thank you.
You're welcome. I have an idea, a little bit of what catalytic converters cost. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Crezo, here's the thing, when you're stealing people's property, things can go left pretty quickly. People have died when they've tried to steal somebody else's property. And you know what ends up happening? If somebody tries to steal somebody's property and they get shot and they die, people say, oh, well, they shouldn't have been stealing their property. So don't do it. And that person, you are not to have any probation. I'm sorry, he's not to have any contact with Christian Theodore Dunbar. All right, good luck to you.
Thank you.
If you need anything, just let the court know. Anyone else who's ready? Ruben Gonzalez.
Yes, Judge.
Yes.
Judge, this case was
I'm
set.
sorry, sir, I forgot your name.
Stephen Gilmore. Judge, this case was set yesterday. I didn't know about it. It's sort of a weird history. This person is a community court participant and I'm the staff attorney for community court.
Mhm.
He had a previous attorney, I think it was Roberto Vargas,
Mhm.
who, once he got into the program, Vargas filed a voucher and got off the case.
Mhm.
And so the case got reappointed to our office. I didn't think it was going to get reappointed to us until the staffing, which is next week.
Mhm.
But they appointed it and they appointed it directly to Renee.
Mhm.
Renee Munoz had no idea that I had been working on it in community court because we didn't have a case for him to have looked at. So this person is staying at San Antonio AIDS Foundation. I received an email that was copied to the state. This is from Matt Howard in the Conviction Integrity Unit. And they've just asked me to come down and ask to recall the warrant. This one client didn't know it was set. The number that I found out Renee had is ancient. We have good contact with him. He's reporting to pretrial services. His officer, Matt Clear, has in CSS that he's staying with placement through the San Antonio AIDS Foundation. So he's in compliance with everything, and so we're just asking to recall the warrant and give us a new setting.
We're not opposed to that, y'all.
All right. Then the court will recall the warrant. However, with regard, was he on a PR bond?
Yes.
All right, I'll recall the warrant, ask that the PR bond be reinstated. Waive fees. And all previous conditions to remain. And when would you all like this set?
So our staffing is next week, so anytime in late July, if the court would like an update at that point, we can bring them back in.
All right, Ms. Ferguson, you want to set it the week of July 29th or the week of July 22nd?
29th works, Judge.
All right, we'll set it for July 29th.
Thank you so much. I appreciate you.
All right, you're welcome. Yes.
Thank you, Judge.
You're welcome. All right. Humberto Casares, he's a Spanish speaker?
Yes.
All right, could you call down an interpreter? Okay, as soon as the interpreter comes, we'll take you up. And probation, I'm going to give you this too. You're welcome. Deputy Lord, they said in Mallorca, there was a meadow tsunami that swallowed up the beach and tourists were fleeing. Mm-hmm. They say it's a mini tsunami. I guess it just swallows up the beach. They have photos of it if you want to go online. It is, because you're just relaxing, then all of a sudden out of nowhere. They say if.
Speaking of relaxing, there are quite a few articles about making your own stuff in the jail. Cocktails, alcohol.
Wow, I didn't know they put that out there.
No, it's real. Bread, oranges is the recommended fruit, while other fruits will do.
Yes.
Apples, if you can't get oranges. You may be asking about the filtering process, but if you stretch out some of the socks, it
Mhm.
serves as like a cotton club, Judge.
Yes.
You may be thinking, but where would you hide it?
No, I'm not thinking that, but okay.
Criminal like me would think it, Judge. No? Get this. The real consensus is to do it kind of in trash bags in the restrooms, but the smart people, what they do is there's somehow an opportunity to empty out fire extinguishers because they have the pressure gauge on them. There's no fire extinguishers in them.
See, your plane just got, you're done.
There goes my method.
The major what they do is they pull out the water from the toilet and they stash it in the toilet and then they put the water on top.
Yep.
And they hold it with a string.
Jason, did you receive the email on Joshua Mejia?
Oh, yeah, I got that here last time. I sent off saying that.
Okay, all right, thank you.
Yes, sir. I saw nobody sent one off.
Okay.
That's awesome. Jeez. They got some sort of. It's cheap, it's brilliant. Very, very creamy. And what?
Spread. Jill recipe spread. There's several versions. I like to do it.
Hi. Hi, it's Umberto Casares.
I had the ish right.
Yeah.
Someone may have thought it was 2:30, not 1:30, so forgive me.
Ah.
I was like, oh, judges meeting, no problem, I'll be there 2:30-ish.
Yeah,
It was ish, but not.
it was, the ish was longer than. Hello. All right, where are we on CPS records?
So Judge, we have them, we had of course signed the agreed order, council and I have discussed them, they're here, the court's file, your honor. And
Okay.
so we are in good shape.
All right, any other discovery?
Judge, I believe I have all the discovery from the state. Zach and I have reached a tentative agreement. I discussed it with Mr. Casares. He's willing to accept it, Judge. The only issue I have, he has an immigration issue that he might have some remedy through a family member. And it's been all this time, I finally was able to get information from this who I can contact to see whether or not they're going to be able to help him in a petition with ICE. He wants to do the plea as soon as possible. He wants to be turned over to ICE, but I want to have time to try and contact a family member, see if they're gonna help him, yes or no. But other than that, we have an agreement by Mr. Casares to take the offer from the state. Judge.
All right,
And
so,
I'm
all
asking for a week or two, Judge, to be able to contact a family member.
right, Ms. Ferguson, can you recall this case for disposition in 2 weeks? All right, we'll be back on July 9th.
Thank you, Judge.
Thank you.
¿Puedo hacer una pregunta? ¿Puedo hacer una pregunta?
Aquí. Sí.
O sea, eso era una pregunta de si salía en libertad condicional, ¿verdad? Pero si sigo en el caso, porque esta señora me robó casi $70,000.
Eso es cosa civil.
Ok. Por eso dije,
Eso es cosa civil.
All right, thank you.
July 9th, Judge.
Yes. Mute, please.
Good afternoon, Your Honor.
Good afternoon. So what is happening with your case?
So, Judge, I spoke with Mr. Delgado this morning. He sent me paperwork. I believe he was having some type of a medical situation that required him to go to a clinic.
Oh, excuse
That's
me,
about the extent.
Nathan. This is not
Yes, Your Honor.
he says,
I'm Sebastian.
all right, he said you're supposed to be Sebastian's lawyer, Delgado, not Albert Delgado.
No, he's Albert. I think he has a different, he's Sebastian.
My attorney is David Garcia.
David Garcia? And what's your name?
Sebastian Delgado.
Oh, okay, I thought I called Albert Delgado. Oh, okay, just have a seat. All right, because I was like, what? All right, so where is Albert Delgado? He's not here.
I believe he's at home, Judge. He didn't appear this morning. He's requesting a reset. He's telling me that he went to the emergency clinic. He was having issues, I guess, with his diabetes.
All right,
So
do you have any
he sent me
documentation?
he sent me that he's an okay return to work tomorrow form. He sent it to me as a picture. I forwarded it to Ms. Ferguson. That's the extent of what I have.
All right, what we'll do is we're going to recall this. We're going to recall it for Monday.
Okay, very good, Judge. We'll be there.
All right, we'll see you on the 9th.
Very good, Judge. Thank you.
Yes. You're welcome.
Bye-bye.
What date did you say, Judge?
The 9th?
The ninth? Or
Yes.
is it a Monday?
I'll just put it on the 9th. Here we go. State that's coming back on July 9th. Yes. Okay, in just one moment. for the offense.
Yes, Your Honor.
Ms. Whitlock, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2. There's a $500 fine. State recommends deferred adjudication. There's to be restitution to Zachary Tompkins, Tompkins, Watson, Watson, and 729266. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing it, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those are recommendations and the court does not have to follow those recommendations? Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
Yes.
State any evidence.
Contained in Exhibit 1 and attachments, Your Honor.
We have no objections, Your Honor.
All right, state, you may be excused.
Thank you.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just hope that you follow the agreement.
All right. How old are you?
29.
All right. Do you have any support system in Bexar County? Any
Yes.
family?
Family?
Yes. Who's your support system?
My ex's family
All right. Where is your family?
in Arizona.
All right. What brought you to San Antonio?
Planning to get married, but that didn't happen.
All right. It's always rough to be following somebody across country, whether you're female or male, because whenever you get to your location, you don't have your family support around you. Is there any reason why you don't want to go back to Arizona?
No, not anymore.
All right. So have you been in contact with your family at all? When's the last time you had contact with them?
Over a year ago.
All right. Why did you break off all contact with them?
A lot of reasons.
All right. Is it have to do with the relationship?
Mm-hmm.
All right. And is that the relationship with Mark Morales? All right.
And others.
Hmm.
And others and my mom.
I will say, Your Honor, her mother has contacted me while she's in jail. We have her contact number and she plans on reconnecting with her.
There you go. Sure.
Thank you.
So are you planning, it's probably, unless there is some type of emotional or physical or some other type of abuse or something that's happening with her mom, it's usually when you're on probation, sure, you can make it on your own. You're close to 30. You can make it on your own. You can do it on your own, but sometimes you need family support. And sometimes when you go back home, people may end up telling you, we told you, but then sometimes you just have to suck it up, because at the end of the day, hopefully moms love their daughters, right? and people won't be bringing it up at every turn. I guarantee you a majority of the people have been in horrible relationships, but they thought that person was the love of their life. And it turns out they're not the love of their life, but they threw away everything to move across country. And sometimes it's hard to swallow your pride because you so want it to work. And then you had all these people telling you it's not going to work, don't go. And then you don't want to go back home because maybe you don't want people to be putting in your face, I told you it would never work, you know? And sometimes people would do that. It's wrong for him to do that. But sometimes to be at a better point in your life, in a better place in your life, you just have to suck it up that some people in the family are going to be saying, we told you so. And guess what? People can say we told you so, but you know what you can tell them? You told me so, and I got out of it. I'm not out of it anymore. So I'm moving on. So do you want to stay in Bexar County or do you want to go back to Arizona?
Let me go back to Arizona to see my family.
All right, so I can order that this be transferred to Arizona, but what county are we talking about?
In Arizona,
Yes. Or do you know the city name?
Tucson.
Tucson, Arizona. All right, we'll figure out what county Tucson, Arizona is. I think if you give probation your parents' address or where you will be staying, they'll be able to figure out what county it's in. There's some beautiful parts to Arizona. I had a chance to go to, I guess it's Monument Valley. And I was like, oh, that's so beautiful. One of my friends in law school was actually is still from there and still lives there. All right, so it's going to be 2 years deferred adjudication. We'll do a transfer. Pima, P-I-N. All right, so it'll be transferred to Pima County, Arizona. There's to be regular reporting by Zoom or in person. Do you have any children? All right, that's a good thing. See, if you would have had children with him, you would have been tied to him forever, but at least most definitely for 18 years. There's going to be regular random UAs. No contact with Mark Morales or any of his relatives. I'm going to want 120 sober meetings in 120 days. How far did you go in school?
I got my associates
All right, and what?
in vet medicine.
All right, what are you planning on doing with the rest of your life?
I want to go back to school to learn coding.
Okay. All right, there's going to be 120 hours of community service restitution. If you obtain your certificate in the culinary arts, I will find that the community service hours are deemed satisfied. We can do a TAP evaluation that can be out of custody. Proof of employment within 45 days. There should be no employment as a home health care provider or with minors. If they do field visits there, if we can have field visits one time per month for 4 months. And then at probation's discretion. Probation, is there anything else she needs?
No, Judge, did you want her to start the transfer process immediately?
Yes.
Or kind of just get her affairs in order first?
Oh, we should probably start it immediately. She needs a situation where she can cut all ties with Mr. Mark Morales.
And Your Honor, we just asked that this probation run concurrent with the county court today. According to me, in a few minutes.
All right, and concurrent with what's county court 8 policy number?
It's county court 4.
Oh, county court 4.
The cause number is 729
Mhm.
266.
All right, this will run concurrent with 729-266. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
All right, it's this document.
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, you're gonna be going to Arizona. If for any reason there's an issue with your probation in Arizona, you can always contact the probation officer here or call the court and we'll see what the issue is. And here's just a side piece of advice for you. Yes, people fall in love. Yes, the relationships will work out. They'll be beautiful. Yes, people will go off and, pick up their life and start a new life over with somebody. But that's very rare that works out. So whenever you picking up your life to move with somebody else, you still need a nest egg. You need a nest egg with money of your own. So if things are not going the way you thought they would go, or if they're mistreating you, you won't be stuck in that relationship because you can't afford to leave. And at the end of the day, parents are supposed to love their children. And guess what? If you made a wrong judgment call and they told you not to get in this relationship and you did it anyway, I guarantee you, if your mom loves you and you pick up the phone and you call her and say, I made a mistake, I never should have came here, I'm sure your mom will get a bus ticket, airfare, or whatever to get you back to Arizona. And that's what you need to concentrate on, okay? And don't get in another relationship until you are positive about who you are and what you want in life and what your hard principles are. You understand? All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. All right, guys, we are done for today. And we will be back on Thursday.
Oh, Judge, we don't have one.